Good morning, children. So we have discussed in our previous lessons about the legislature, and later we have discussed about the executive. So under legislature we covered the Lok Sabha, Rajya Sabha, and other things. And later in the executive we have learnt about president, vice president, and the prime minister. Right. So now in this chapter, the judiciary, we are going to learn about the third important organ of the government, which is the judiciary. So judiciary is a very important so the judiciary is a very important organ of the government under the federal system of Indian government. That means where there are three wings of government, there must be a balance. So if only executive and legislature are there, if any differences come between these two, or if there is a kind of a problem between central and state governments, there must be a third party to address this kind of problems, and also to safeguard the constitution in this country. There must be a third organ that acts independently without the influence of legislature and executive. So in that kind of system, India has adapted a judicial mechanism also. So Indian judiciary, is a kind of integrated judiciary. So integrated judiciary means there are there is a highest court at national level, and every state will have their independent courts. So we will study in detail what courts are present in India, how they function, and what are the powers, how judges are appointed. All such details we are going to learn in this chapter. So let us proceed to the chapter. So the judiciary, it forms the third pillar of democracy. So in democracy, where people elect their governments, is having three pillars. So one is the legislative, which is law-making organ. The other is executive, which implements the laws made, and judiciary is the third pillar to monitor all these two also. Okay, this is an independent body because, as I said earlier, there is a mechanism required to monitor independently these two wings of the government, and so that the democracy that is given by constitution can be saved. So but that doesn't mean that it can function as it likes. There is a requirement of an independent mechanism. With independent mechanism, these three are required to make the democracy function smoothly. So the judiciary interprets the laws made by legislature and sees to it that they are properly implemented by the chief, the executive. So here, what do you mean by this? The judiciary, it interprets the laws. That means the legislature or the parliament makes laws. And when they make laws, the judiciary can interpret the laws. Why it will interpret the laws? Because if those laws are against constitution, then this judiciary will act as a checking mechanism. And if laws made by parliament are not implemented, then the executive will also be questioned by judiciary. So in this connection, if laws are made against constitution, judiciary will go and make it constitutionally valid. And if executive is not implementing the laws that are made, even then also the judiciary will keep a check on such things. It can question why the executive is not implementing. It has the power to make the executive to implement the laws. So that is the initial description on the judicial wing. The judiciary not only protects the rights of the citizens, but also resolves the disputes between individual citizens, between center and states, and between states. So the judiciary, where courts are involved, what they do is they not only try to protect the constitution, and they not only make laws getting if laws are not implemented, then they'll come to rescue. Not only that kind of things, but also what this judiciary will do is it will protect the rights of the citizens. So Constitution has given certain rights to citizens. So like fundamental rights you take, and no, if legislative and executive, if they try to violate the rights, then it is the judiciary that comes in to help. And it also resolves the disputes between individual citizens. So if citizens have any legal cases and all, so they can even approach to the court and get them solved legally. That's dispute means a problem between individuals. It also involves to resolve the disputes between the central government and state governments. Okay, so if central and state government is having some problem, then legally, then the courts will interfere, and they'll then they'll try to solve the disputes. Otherwise, the federal nature cannot be seen in this country. And also, if there is problem between one or two states, then also the courts can come and try to settle the disputes. In India, we have a single integrated system of courts with Supreme Court at the top. This means that there are no separate set of laws, and a single civil and criminal procedure operates throughout the country. So if you look at the pyramid of this, you look at the pyramid in this picture, the Supreme Court stands at the top of the country. So the highest court for the entire country is the Supreme Court. And for every state we have high courts, and for every district we have subordinate courts. And if you look at the system of judiciary in India, it is referred as integrated system. What do you mean by integrated system of courts? That means these courts are all interlinked with each other. If you are not happy with the decision of subordinate courts, you can go to High Court. If you are not happy with the judgment of High Court, you can appeal them in Supreme Court. So the courts are interlinked, and but there is a highest court also at the national level. So this kind of arrangement is called integrated system. It seems that Supreme Court is at the top, but still all the courts are interlinked. The Supreme Court governs all other courts in India. So this kind of arrangement is called integrated system of courts. And also we have single set of civil and criminal code of laws throughout the country. So suppose that means you for any crime, okay, suppose civil cases, civil means like disputes regarding the properties, any marriage related cases, all such things. And you take criminal, criminal means where crime is involved. The code of law, okay, the law to deal criminal cases and civil cases are same throughout the country. There is no differences in each state. Every state in this country follows same civil and criminal procedure of law. It is not that you change the state and your law will change for criminal case. It is not that there will be another kind of law if you go to some other state for a particular crime or a particular civil case. Wherever you go in this country, civil laws and criminal laws are same. And below the Supreme Court stands the high courts of different states. So in the hierarchical order, the Supreme Court stands at the top. Hence it is called apex court. Apex means the tip of the highest portion of a tree we call generally as apex. Similarly, in the court system, the highest court is Supreme Court. And at every state, again, we have high courts. And under each high court, there is a hierarchy of subordinate courts. So the high courts function state as a headquarter, subordinate courts function district as a headquarter. All cases coming from lower courts can be taken to high court and ultimately to Supreme Court by way of appeal. So if a subordinate court passes a judgment, then that is not the end. The petitioner can appeal to High Court. And if still he feels that High Court is also not, he feels that he has got some injustice has been done, still he can appeal to Supreme Court. So but once Supreme Court passes judgment, that is final. So there is no other court of law to appeal. So Supreme Court is a final court of appeal in this country. So this is the introduction of the courts and their hierarchy. So in this, let us start in the hierarchy of courts. Let us start discussing about the Supreme Court. So this is the Supreme Court building in New Delhi. So you can see in the picture here, this is how the Supreme Court building looks. It is situated in New Delhi, and this is called the apex of Indian judiciary. That means the highest court with regard to Indian judicial system is the Supreme Court. There is no other court you can appeal after this court. It is at the top of all courts in India. All sorts of disputes and differences arising between center and the states are settled by Supreme Court. See this, there are many functions of Supreme Court. So, but Supreme Court in a big way, in a very big manner, it tries to settle the disputes between the central government and state governments. So in federal structure of India, balance between central and state government is very important. To bring that balance, continuously, there must be a third independent body which can settle the disputes that arise in courts. So to settle the disputes, Supreme Court has been given authority by Constitution, and therefore it is called the guardian of the Constitution, or the final interpreter of the Constitution. So here what happens is, if the state or central governments, if they try to violate the Constitution of India, then the Supreme Court comes to the rescue of implementing the Constitution. So through laws and other ways and means, the legislature may try to violate Constitution. That connection, the Supreme Court comes and it tries to settle that unconstitutional things to prevail. Hence, it is called the guardian of the Constitution, or the final interpreter. If anybody has some kind of doubts with the provisions in the Constitution, because generally when the legislative bodies, when they make laws, they may try, they may unknowingly, they may go against Constitution. If anybody takes this issue to Supreme Court, it interprets the Constitution and tries to understand whether that law is constitutional or not. So it is final interpreter of the Constitution. Nobody can interpret, like suppose if high courts are there, subordinate courts are there, they sometimes interpret the Constitution, but at supreme level, Supreme Court is the final interpreter of the Constitution. So here interpretation refers to understanding Constitution. Okay, so the final person who can understand Constitution in a more better way is Supreme Court, and the decisions of Supreme Court on this interpretation will be very supreme, and it is binding for all other courts to follow. Composition: the Supreme Court consists of Chief Justice of India and 3 other judges. So the Supreme Court, so what does the Supreme Court has? They have judges and a Chief Justice. Okay, Chief Justice will be there and 3 other judges will be there. And the judges of Supreme Court are appointed by President in consultation with the judges of Supreme Court. So what happened was, generally there will be a Chief Justice and other judges. If the president know if there is a vacancy in Supreme Court judge, then what president will do? He is the person to appoint judges to Supreme Court. So he will consult the Chief Justice of Supreme Court and other judges in appointing new judges. Okay, so that's how president will appoint judges. And High Court judges are also appointed by President by consulting Supreme Court, Chief Justice and judges. So that's how the appointment of judges takes place. The Chief Justice of India is appointed on the basis of seniority. For example, you take here, he is the present Chief Justice of India. Okay, Babde, his name is Babde. Earlier, he will be like these judges in Supreme Court. As per seniority, suppose before this Babde, there was Tarun Gogoi. He was another, he was Chief Justice, and Tarun Gogoi retired. When he retired, as per seniority, Justice Babde will become, or he was promoted as Chief Justice of India. And suppose now in his place, one more judge have to be kept. That judge appointment is done by President. Even Chief Justice is appointed by President. So once Justice Babde is promoted as Chief Justice, a vacancy arises. To fill that vacancy, President will appoint a judge. How he will appoint a judge? By taking the view of other judges in Supreme Court as well as the Chief Justice. Even for High Courts, the same process continues. Only in the appointment of Chief Justice, President will not take anybody's consultation, because the senior most judge needs to be automatically promoted as Chief Justice of Supreme Court. So this is about the composition of Supreme Court. So what are the qualifications to become a Supreme Court judge? So a person to be a judge of Supreme Court must have the following qualifications. He must be a citizen of India. This is, I think, a very simple point which you all understand. He must have been a judge of High Court for at least 5 years. So High Court, what is this High Court? This is the highest court at a state level, right? A High Court will function with state as a headquarters, and anybody, any judge who has got an experience of 5 years as a judge in High Court, okay, then he can be promoted as, or he can be appointed as Supreme Court judge. So to get appointed as Supreme Court judge, generally the judges from High Court are taken, and these judges must have an experience of 5 years. They should have put up an experience of 5 years as High Court judges in their respective High Courts, so as to get appointed as judges of Supreme Court. Or he must be an advocate of a High Court for not less than 10 years. If he is a judge of High Court and he is having 5 years experience, then he can be promoted as Supreme Court judge. Or if he is having experience as if he is having 10 years experience as a lawyer or advocate in a High Court, then he can also be appointed as Supreme Court judge. Either he must be a judge with 5 years in a particular High Court, or he must be an advocate or lawyer in a High Court for 10 years. So they are all qualified people to get appointed as judges. See, that doesn't mean that once they get that experience, they'll be promoted. There must also be a vacancy in Supreme Court during that time, and accordingly they will notify and they'll pick up the candidates like this. And he must be an eminent jurist in the opinion of the President. So this is another important point. What do you mean by eminent jurist? Eminent jurist means, see, in this country, not only the advocates and judges have knowledge on judicial things. Suppose you take a university, a law university. There are many scholars who are working on how to policy of lawmaking, reforms of laws, or the reforms on judiciary, what changes, what are the updates, what are the most updates happening in the field of lawmaking process. There will be scholars working, like who did their PhDs, they might be working as professors in universities and all. They're all very eminent, means they're very good at jurisdiction, and they're very good at the judicial aspects. In the opinion of President, okay, if he feels that a particular professor or a particular scholar in the field of law and other departments, he can also promote them as he can also appoint them as judges of Supreme Court, because such people, such professors or scholars who have good grip on lawmaking and laws, they can definitely do better in giving judgments. So they will also be appointed as judges in the opinion of president. If the president feels that that particular person who is working as a scholar or professor or some kind of eminent jurist, then he can also be appointed as a Supreme Court judge by president. So all judges are appointed by president only. So now let us try to understand what is the term of a Supreme Court judge. So a judge of Supreme Court remains in office. Term is how many years he will be working as a judge. What is his time period to work as a judge? So a judge of Supreme Court remains in office till he attains the age of 65 years. So the age for retirement for a Supreme Court judge is 65 years. So till a judge reaches 65 years, he can function in judge as a in Supreme Court. He may submit his resignation to the president. So why he'll submit his resignation? Any judge will submit resignation to president. It may be of various reasons. So, but it should be submitted to president. So here, as the appointment order to a Supreme Court judge is given by president, resignation also must be submitted to president only. And a judge of Supreme Court cannot be removed from office except by an order of president on the ground of proved misbehavior. So, see, a judge of Supreme Court cannot be just removed. It is a very elaborate and complicated process. Even though the orders are issued by president for the removal, it is not that easy for to remove a Supreme Court judge. Both Parliament houses have to agree for the removal with a voting process, as well as only after that voting process in favor of removal is completed, only then the president will issue the removal order, and then the judge is said to be removed. Because to protect the independent nature of or to make the judges more independent in functioning, this kind of securities or safeguards have been given for them to function more independently. So on the ground of proved misbehavior, that means when he is in office, if a judge is in office and if he tries to violate the rules of the constitution and he functions, or if he resorts to any corruption practices and other things, then if they are proved in both parliament houses, then the president will issue the order of removal. And salary. The judges receive their salary from Consolidated Fund of India. So what is this Consolidated Fund of India? It is a account of India. You can consider it like a bank account, something like that, where the taxes that all the income that is the central government is getting is kept in it. Okay. The central government gets income through various ways, through taxes, through loan repayments, through some kind of loans they take from other countries. All such things they come and they get into the account of Consolidated Fund of India. The salaries of judges are paid directly from this account. Okay, they're not dependent on any, what do you say, any political, any legislative or any administrative unit. They are dependent on Consolidated Fund of India. Like directly, the government sends the salaries from Consolidated of India, and it cannot be lowered during their tenure except the period of financial emergency. Except in the situation of financial emergency, where a country like India, suppose what is financial emergency here? If our country fails to pay our loans, if we fail to meet our day-to-day expenditure because of more debts, because of financial indiscipline, we may fall into debts, and the value of currency may decrease. And during such situations, the government, to protect the value of money, it may declare financial emergency. So only during such situations, the salaries of judges can be altered or they can be changed. Otherwise, The governments have no power to bring any changes. They can increase the salaries, but they cannot be reduced to the discomfort of the judges. So this is about the term and salaries of Supreme Court judges.